Good evening again, folks, and welcome to Gorman on Target. This is a program about firearm safety, training, and education that is brought to you by the Wilson Hill Pistol Club of Manchester, Manchester's very good, quiet, unknown secret. Tonight, we're going to be hitting a real heavy-duty topic. And I would like to introduce my guests here this evening. To my immediate right, we have Seth Hipple. Seth is an attorney, practicing an attorney, and has a law firm in Concord, and practices criminal law, among other things, I'm sure, Seth. So he will be guiding us this evening in regards to the law. Also, this evening's guest is Mr. Vince McHugh. Vince was with us here last week.
Yep, nice to be back.
And Vince has a unique position for this topic in that he is on the board of directors for a mental health wellness center, and he is also on the board of directors of the Wilson Hill Pistol Club. So what we're going to be discussing tonight here, ladies and gentlemen, is the relationships between people who have emotional, psychological type of problems and ownership of firearms and the Second Amendment.
Sure.
And what are the thresholds here, and what's that all about? Because there's a lot of myth, there's a lot of confusion, and there is certainly a lot of ignorance out there. So, having said that, gentlemen, let me give you a hypothetical case here. There is somebody who is an alcoholic. He's a confirmed alcoholic, no question about it. He's under doctor's care for this alcoholism. The doctor says one day, I really think that you need to go to a rehabilitation center for 60 days so that they can work on this problem under supervised conditions. At that point, the fellow goes to this institution, stays there for his 60 days, and now when he comes out, I'm kind of wondering what happens to his Second Amendment rights as far as ownership of firearms and things of that nature. So, Vince, do you have any thoughts on that?
Sure. I mean, that's one of the things that I think this conversation needs to be talked about, because there's a number of scenarios where people either go to get help on their own, they agree to go in. Obviously, very different if someone gets committed. That might be a different scenario, and we'll talk about that. But it also could affect whether someone is going to get help. If someone in New Hampshire, we have a lot of people who are avid hunters, avid sportsmen, people who like to do target shooting. There's been a concern, and people have voiced this to me as well. If I was to go in and get help in a situation like that, would I lose my ability to? Would I lose my Second Amendment rights to keep and bear firearms? And I think we're very privileged today also to have Seth here from a legal point of view, because it seems to me there's a lot of confusion out there as to what is the law and what does it actually make someone a prohibited person. From
Seth, what would happen in the situation, that hypothetical situation?
In that hypothetical situation, it wouldn't affect that person's Second Amendment rights at all as such. There's two things that can happen that would trigger that person to be a prohibited person under the Gun Control Act of 1968 under federal law. And those two situations are that they're either adjudicated mental defective, and Vince and I were talking before the show, obviously this is...
It's a term we really hate in the mental wellness, using the term mental defective, but that's what the law actually says. So when Seth's saying that we're not using that term to be offensive, it was simply quoting what the law says. But we do acknowledge it's a very offensive term to many people.
Thank you, Vince. I'm sure there's a clarification right there.
Sure.
I was totally unaware of that myself. So continue.
So that's the statutory language: adjudicated mental defective or committed to a mental institution. Now, the wonderful thing about this statute is that neither of those terms are defined. So, of course, it's up to the courts over the years to try and define them. The federal regulations have defined them, though, so we can, in the case that you're talking about, we can get to adjudicated mental defective at a future point, but the case that you're talking about, we're talking about being committed to a mental institution. Now, there's a few things about checking yourself into a rehabilitation program for alcoholism. that would keep it from applying to that particular requirement. First of all, the person checked themselves in. So if you voluntarily agree to treatment, even at a mental institution for a mental disorder, that is not going to cause you to be a prohibited person, because you actually have to be committed by a legal authority. So even if your doctor makes a recommendation, or in New Hampshire, for instance, if you show up to the hospital and they're concerned about whether you're a danger to yourself or a danger to others, they can keep you for a 72-hour observation period without any court involvement. That is not a triggering event either, because that is a doctor's decision, not a legal decision. So to pass muster to become a prohibited person in this situation, it would have to be a formal commitment by a board or a government agency or a judge or a court, some kind of governmental agency that would say that you were involuntarily committed because you're a danger to yourself or others.
Let me get back to Vince on that one a little bit. Vince, in your capacity as a director of your Wellness Institute,
Sure.
Have you run across situations where people have needed to utilize, or a doctor has utilized the 72-hour?
Certainly, that definitely happens. I know it happens here in New Hampshire as well. And the ability for someone to get that help without fearing that they're going to put themselves in a situation where they'll lose some of their rights is important. I think anybody who needs help. I heard a statistic recently that 1 in 10 Americans are on some sort of antidepressant. Which I know many people who take them, and the key is they're not a danger to themselves or others. Nobody's ever even suggested it. They might have went to the doctor and said, "Hey, I'm feeling kind of blue lately. I can't shake this," and the doctor says, "Oh, well, why don't we try Zoloft, or why don't we try Paxil or something?" And they do that, and it makes them feel better. And they've never fallen into that category where they have been a danger to themselves or others. I don't think any reasonable person would want to see someone who is a danger to themselves or others have access to a firearm. So, but there are already laws on the books that address that. And I know you're a legislator, Don, so that's something you always talk about. What if we're going to put a new law out, and people seem to always be calling for new laws, there should be some discussion about that. I think you had a couple of things questions you like to ask about.
Yeah, well, thank you. Now you got me on the spot. Yeah, basically, and this is my own personal thing. When I was in the legislature, I have a law or bill come before committee or on the floor. I always ask myself 3 questions. First question is, what is the demonstrated need for this law? Second question, is it already on the books? Unfortunately, we have a lot of legislators that want to put in a new law. They don't research, they don't do their homework, they don't find out that it's probably already on the book somewhere in some other statute someplace. And then last of all, and I really want to get into this one later on, is it enforceable?
Okay. So
that's my own personal criteria that I start off by measuring every piece of legislation I look at.
I think those are great questions, because every time there is a national tragedy, whether it's Sandy Hook or Columbine, the media always calls for new gun laws. And when I began to look into it myself, I began to see that there is laws on the books. I think Seth just described, situations where if someone rises to that occasion where they're either adjudicated mentally defective or have been committed, I like you said the word too, involuntary committed, because if I voluntarily commit, I know that I need help. I'm willing to get the help. That's a different mental state than not willing to get the help.
And that's an important distinction in the law, because the law does not punish people who voluntarily commit themselves to a mental institution. So that's an important distinction. I mean, obviously, like Vince was saying, if you go to a counselor, or if you have a prescription for some sort of antidepressant or other type of a drug like that, that is not going to be an issue at all. But a lot of times when people who have been in a situation where maybe they've checked themselves into the hospital and they want to know, how do I know if I've been involuntarily committed? There's a few things that you can look for. First of all, a person in that situation has a right to a full and fair hearing. So if they never saw a judge,
Let me stop you right there.
Sure.
What does a full and fair hearing mean? I think I know what it means, but if you
sure,
could explain.
before a person has their liberty curtailed by being involuntarily committed to a mental institution where they can't leave, their liberty is affected, they have the right to have a hearing. They can have an attorney at that hearing. They can put evidence in front of the administrative body or the court. The point is, though, it's a formal proceeding. So if this person when a person comes to me and says, I don't know if I am prohibited or not, I'll ask them, did you ever see a judge? Did you ever go before any kind of board or commission for any kind of hearing? No, I just told my doctor that I thought, my doctor said they thought I needed to go to this place and I went. That's not a problem. Like I said, the law does not punish you for volunteering to get treatment. So good rule of thumb in this situation, if a person is concerned about whether or not their treatment is going to harm their firearms rights, follow their doctor's recommendations. If their doctor recommends that they go to a mental institution, they should go voluntarily. That's the best way for them to protect their rights.
Very good.
One thing that comes to mind, since a judge would be involved in both of those threshold events, whether I've been adjudicated, again, mentally defective, my apologies for the term, or I've been involuntary committed, since a judge is involved in both of those things, both of those threshold events, enforcement might not be that difficult because you're already in the legal system rather than the medical at that point. So that might be more easy to enforce.
That brings up a good question that I have floating around the back of my mind that I'm totally have no idea. You have a lot of HIPAA laws that are on the books now where medical records and things of that nature, treatment, what have you, are protected by law.
Absolutely.
So now if we have a situation where you're going to a hearing, let's say with a judge, and you are getting adjudicated to fill in the blank, where does this HIPAA law and public record, and where's that fuzzy line defined?
Well, there's a few different situations where we have to consider. One of them, of course, is the hearing itself. There are exceptions in HIPAA to allow that evidence to come forward in a hearing on these issues. But the answer, the issue then later is, well, what about when that person is adjudicated a mental defective or committed to an institution and they go to get a background check and it comes back? Does that violate HIPAA? And the answer is no, for a few reasons. First of all, these adjudications that we're talking about are legal decisions. They're not medical ones, so they fall outside of HIPAA. Secondly, the denial that would come back on a background check is simply going to say that the person's denied. It doesn't actually give a reason. The person, to find out why they were denied, would have to write a letter to the NICS system and ask for the reason to be given in writing, and that takes quite a long time. But that's so that HIPAA doesn't come into play there.
Okay, so. Following up on that then, so I've gone in front of a judge and there's been a commitment order issued. Now, is this fall under public record? I, as a civilian, can I go to the court and say, under Public Information Act, I'd like to know about this case. I want to know what happened to this guy.
Generally, these types of hearings are not available to the public, but there's no hard and fast rules on these kind of things. But the thing about it to remember is that if a person agrees to treatment, there isn't going to be a hearing. There's only a hearing if the doctor says, this person needs to be committed to a mental institution. I'm going to file a petition to make sure that this person doesn't walk out of the hospital. And then the person says, no, I don't think I should have to go. That's the only time there's a hearing. So in most situations, there's not going to be a hearing.
Okay, that sounds great. Vince, having heard that, I know you and I had talked about that particular line.
Sure, it was a concern of mine.
show.
Obviously, being a part of mental health centers, that people have their privacy, but also that their rights are not violated, and that they can like I said, if they're in a situation like that and the judge is involved, at that point they've kind of crossed a threshold where a judge has actually either committed them or made that ruling on the term mentally defective. So at that point, then you actually get into a very different area. And I think maybe that puts a little bit more burden on the mental health system to determine, the question that really needs to be asked, is somebody a danger to themselves or others, in that situation, Because I don't think anybody, like I said, no reasonable person wants to see someone who's a danger to themselves rather have access to firearms. It's one of the reasons that I always make sure firearms are locked up. I don't leave them out or leave them in a drawer somewhere because I know I'm responsible for those firearms.
Sure.
I want to make sure
You
that someone
bet.
who doesn't have a legal right to them doesn't get access to them. So as a homeowner, I think it's important that if we have firearms, that they're in a controlled situation and
Sure.
access is not made available to
Seth, let me ask you this, kind of quickly off the top of my head, going back over your cases and case laws, and does there anything stand out on this topic that you've handled or know about, or something that might shed a little light on this?
I'm sorry, so you're asking if there's anything I've handled that
Yeah.
These situations normally come up in a situation where a person is either, say, in a criminal situation, pleading to something, or maybe undergoing some sort of voluntary treatment. So if a person gets a DUI, for instance, and I suggest that they voluntarily take an inpatient alcohol or drug abuse program, people often want to know, does this affect my firearms rights? So that kind of thing will come up a lot. But and I also get emails from people who will say, 5, 6, 7 years ago, I had this terrible situation that happened to me. I had a hard time coping, was in the hospital, ended up spending some time at a center for a while. Does this affect my rights? So those are generally the times when these come up. We haven't, I don't think, defined what adjudicated mental defective means, and I'd like to do that really quickly.
By
before
all
we go.
means, you go right ahead.
And just like involuntarily committed, the adjudicated mentally defective requirement is that the decision be made by a court or commission or board or other lawful authority. So once again, this is not a situation where a person's doctor or counselor or psychiatrist can take away their rights. It has to be done by a court. Once again, a person has a due process right before they have any rights revoked. They have a due process right to a hearing. And basically that determination has to be that they're either a danger to themselves or others. But the key here is not just that they're a danger to themselves or others, but that they're a danger to themselves or others because of mental incapacity or mental disease or disorder, or what the law refers to as subnormal intelligence or marked subnormal intelligence. So it's not just that anybody who's a danger to themselves or others, it has to be for a mental reason. Okay. The other reason that a person can be adjudicated mental defective is that they lack the mental capacity to manage their own affairs. So for instance, if a parent were to file a petition in the probate court to say, my 25-year-old son is severely mentally disabled and he's not able to manage his own affairs, I would like to be appointed guardian for him. If the court after a hearing finds that this person is not able to manage their own affairs because of some sort of mental handicap or disorder, then that would meet the standard under this for having that person's firearms rights taken away.
Oh, okay. One question that comes up in my mind is there any way to appeal it if I've had mental illness or I've gone through an episode or a series of maybe a bad time in my life and 10 years later I'm doing very well? Is it a permanent thing? Can it never change? Can it be changed?
Vince, you're hitting the nail right on the head of what I was going to get into a little bit later, but since you brought it up, I guess we're here. Veterans. We have a lot of situations where veterans have been in combat and come back to the States with severe mental situations because of the stress that they went through in the various campaigns and things like that. So what happens in a situation, the veteran comes in and is definitely needs to go through some rehabilitation. There's no ifs, ands, or buts of it. And what I'm a little bit confused on is at a period down the line, whatever that period is, the doctors say, well, this fellow's okay now. He's got all of his problems behind us,
right,
and he can function in the society.
Sure. And not just veterans. I mean, that can happen in someone who's not served in the military, where they've gone through a bad period, they've gotten the help they need, it's been very effective. Where does that person stand after the fact if they're better?
The answer depends on which court adjudicated them mental defective or committed them to an institution. So if it's a federal court, such as the Veterans Affairs system or commission, the federal law under the NICS Improvement Act of 2007. NICS, by the way, is the National Instant Criminal Background Check System,
Okay.
NICS.
Oh, we're familiar
So-
with NICS.
Yeah, so just for the viewers. So if the NICS Improvement Act of 2007 said that under federal law, once a person has been cleared as no longer a threat to themselves or others, the supervisory authority is supposed to report to NICS that this situation no longer bars this person from possessing a firearm. So in that situation, in federal law, this will automatically happen, or a person can petition for it to happen. The problem is that under state law, there is no equivalent way to annul a finding such as this. So the federal law gives the states the right and the ability to set up systems so that after a finding has been entered that the person's no longer a threat, that this can be taken off their record so that they can regain their firearms rights. But New Hampshire has not, since 2007, actually passed anything that would allow a person to do this. Now, it's possible that an attorney could craft a remedy on their own, where an attorney could say, okay, I'm going to petition the court, for instance, to reopen and dismiss this case, or to reopen and find a different finding. That's a little bit of creative lawyering there, but the statute really needs to be amended to match the federal law that says that when a person is no longer a threat, once the situation has been dealt with and is passed, then a person should have their firearms rights back.
So we, at present, we in New Hampshire do not have that as a statute.
No.
Wow.
That might be something worth talking to the legislature about to see if we could, and I like the idea of matching the federal statute. It's already in place and it's working at the federal level. It might be nice to see New Hampshire also have something similar. Because that would affect like someone in New Hampshire. There's just, at this point, unless you said you had a creative lawyer opening a case again, if I lose my firearm rights in New Hampshire, I have no way to get those back.
And of course, even with a creative lawyer, judges generally don't like to do things that are too far outside the norm, because once they get too far outside the norm, they're more likely to get overturned. They don't like that.
Right.
So it would be much more helpful if the legislature gave the courts some kind of guidance that they could follow. Because if I file a petition to reopen the case, the judge is going to say, well, I don't know that I actually have the authority to do this. Some judges may grant it, most probably won't, because they don't have any kind of statutory guidance. So it is necessary that the legislature take a look at this and make sure that the law is updated to comport with the 2007 NICS Improvement Act.
Wow, okay. Now I think we're starting to get our teeth into the situation here.
Do you know anybody in the legislature that might be able to help
Yeah,
out?
I've got, there's a couple of guys I know up there. Yeah, I'll be, I didn't run this year. I didn't run for the House, so obviously I didn't get elected. But a lot of my friends that I helped and guided to get elected did get elected, so I'll probably be up the State House at least first several months, doing a lot of coaching.
There you go.
Have you any idea about specifically how that would be worded? I mean, obviously RSA such and such, follow the federal law is not a bill.
I can't, give you wording specifically right now, but basically it would give some sort of procedure where a person could either petition the court to meet a burden to show that they were no longer meeting the standards of those two requirements, adjudicated mentally defective or involuntarily committed. If after those things had happened, there could be a set time period that would have to expire, then the person would have to possibly introduce evidence to the court to show that they were no longer under this mental incapacity that caused them to be a danger to themselves or others. And then the court could order it. The state police could then update those records with the National Instant Criminal Background Check System, so that when that person then would go to buy a firearm, they would not be denied anymore.
We do something similar for felons, don't we? If someone had a felony and it got expunged, is that also currently available, where someone could have their rights restored if they were no longer, considered a felon?
That's correct. And federal or felons or misdemeanors can all be annulled in New Hampshire. So, well, most felonies or misdemeanors. There are a short list of statutes that cannot be annulled ever, but for most crimes, a person, after they've waited a certain period of time they've completed their sentence, they've paid their debt to society, they haven't gotten in any trouble
Right.
for a specific period of time. For instance, for a Class A felony, they have to wait 10 years from the end of their sentence. So they have to serve their sentence, complete any kind of aftercare, and make sure that their sentence is completely done. From that date, then they have to wait 10 years. They can't get in trouble again for those 10 years. After that, then they can petition the court to say, all right, so I've been a good citizen for 10 years since the end of my sentence.
Right.
I want to be able to get a job. I want to have my firearms rights restored. I want to be able to pass certain background checks. And this is a way that New Hampshire makes sure that basically if a person has paid their debt to society and has been rehabilitated, that their old criminal record doesn't hold them back.
Right.
And yes, I think it would make sense to have something like that in the mental health aspect as well.
Yeah, that sounds like a reasonable thing.
Vince, do you do you run into this in your day-to-day workings? I mean, do you have people come in and say, you know, I applied for a permit or a license, or I own firearms?
Generally speaking, I don't run into it a lot of times. A lot of the people we deal with at the mental health center tend to be on the poorer side, not a lot of disposable income. So, I mean, firearms tend to be a little expensive to purchase, so I don't run into it as much there. But I get into conversations with friends who maybe are on, an antidepressant. I know a number of people, and again, people I know very well, and I know they're not in a situation where I'm worried about their being a threat to somebody or even to themselves. But sometimes the conversation comes up where there's a concern. Recently, there was a scare, and I don't know that this ever was proven true, but word was going around the internet, if that your doctor may ask you if you own firearms, and people were very concerned about having that
Right.
conversation because we
Right.
didn't know what the law said.
Right.
And so because of that concern, someone may not get help that could really, help them. And so my understanding is I don't believe that conversation is happening between doctors and their patients, although people have said so. I never found any evidence that proved it to be true. But we don't want to put people in a situation where they can't feel they can be honest and speak to their doctors.
Yeah, I agree with that one 100%. It's one of the problems I have with street drugs and criminals and things like that. If you can't go to your doctor and say, I'm hooked on heroin, I know it,
Right.
what can I do? How do I seek help legally? Well, they don't feel they can do that. What are they going to do? They're going back to the street.
Right.
So,
Right.
anyway, we did not cover one of my very important elements that I believe on any legislation, but especially on this topic, is how is it enforced? So what I'd like to ask you gentlemen is if you would be willing to come back and do another show, maybe primarily on enforcement and that. I know, Vince, Seth, that laws and more laws, and the criminal is going to go out there and break the law, rob a bank. He's not going to say, I got to get out and register my gun first,
Right.
So I think I'd like to get into that a little bit, but I was wondering if you gentlemen
Sure,
would
I'd be happy to.
be able to,
Sure.
to do that. Well, okay. Well, this has been really, I hope it's been enlightening for you folks up there. We're going to close now, and I want to thank my two guests for coming tonight. And this is Don Gorman, Gorman on Target, Firearm Safety Training and Education. Hope to see you shortly. Have a good night. Thank you.